Elected officials in Minnesota are pursuing a lawsuit against the federal government after the shooting death of Renee Good by ICE agents.
The hope is to stop or at least reduce the flow of immigration officers in the state.
All right, joining us now, our chief of the analyst, Khalif Rhodes. Khalif, the state's arguing that ICE doesn't have the duty or the ability to stop some of these people, do these unlawful searches. They're also saying that they're being targeted. What do you make of this lawsuit?
Yeah, they're making a number of arguments. It's 80 plus pages. I've had opportunity to read. A majority of it went to the key points that I thought would be great to pull out here. I also had opportunity to look at the press conference with the Attorney General and the Mayor of Minneapolis. A number of things jump off the page to me. And the biggest thing were those issues that you talk about have been addressed and are argued within the court already. In other states and in other cities have already attempted to stop ICE and Department of Homeland Security from doing these type of racial profilings. They're doing these random stops with no reasonable suspicion. But this one hits on a novel argument that I haven't seen anyone else address, and this is the Federalist argument under the 10th Amendment. Specifically, the 10th Amendment says that the federal government can only do things that are specifically laid out in the Constitution. If they're not laid out in the Constitution, you don't have authority to do that. And so they're asking for two parts. They're saying, give us declaratory judgment. Court, go and look at the Constitution and say, does the Constitution allow them to do these very things that they're asking to do? And then B, give us an injunction. We've talked about injunctions a number of times here on the show. They're asking for a preliminary and a permanent injunction. But those two are the biggest thing. And this argument, with this 10th Amendment argument, is a very, very strong argument. It's saying that we want to be able to do our basic things that we should do as a state: police powers, authority to protect health and safety in our state. And because this, they've called it a federal invasion, has occurred, this surge of thousands of federal law enforcement officers, now we're unable to do the things that we're supposed to do that's enumerated as a state's right. The part that is extremely unique to me is that the very party that has been pushing states' rights on everything else is now having it flipped against them by the state of Minnesota, been saying, listen, you guys are now trampling on our state's rights. And so it's a unique argument really towards the end of their complaint. But to me, that's the most important part.
So Chicago's joining Minneapolis in this, saying, judges, listen, we want you to stop these operations from happening in our cities and in our states. What has to happen? What does the judge need to see evidence-wise or hear to go, okay, I'm making a decision, this is going to stop?
That's going to be on the injunctive side, that preliminary and permanent injunction. It's going to say likelihood of success from the marriage, irreparable harm, this balancing of the public policy and what's in the public interest. And so they're going to say, well, is it likely that you'll be successful in the marriage for this 10th Amendment argument? That's the first thing. Some of the things that Julian was talking about, are you trampling on individuals' rights? Do you have a constitutional right to stop? Have you even met reasonable suspicion? And the arguments that are coming out of Minnesota, specifically Minneapolis, are troubling. They're saying that the ICE agents are leaving folks on the side of the road in cars abandoned with hands tied up. They're saying they're pepper spraying folks right in their face. These are the arguments that the Attorney General talked about yesterday in a press conference, that are, if you were a law enforcement agent, these would be extremely bad scenarios to happen, and there would be accountability. What they're arguing is there is no accountability, and they're asking the court to remove them. So those instances that have occurred time and time again, they're using as examples as to why. So you ask the question what the court will need to look at. They'll look at these examples that they're listing and saying you are abusing your power and you don't even have the power to do the things that you're abusing.
How quickly can we expect this to make its way through the courts, especially when the situation, as officials in Minnesota are saying, are dire and they want this to end as soon as possible?
Yeah, I mean, this is something that's going to be fast. If I'm looking for an injunction, it's now. It's immediate. It's not that, remember, the irreparable harm is the money portion. Money can't fix this. But also, I'm asking for a preliminary and a permanent one. So that preliminary injunctive hearing should happen instantly, as soon as possible. This isn't something that you can put off next month, next year. What would happen if I'm looking in my crystal ball is they have a hearing on the merits, the judge rules one way or the other, and the Trump administration or the other side that loses will then file an appeal to some other court. That portion may be longer, but this first hearing is going to happen fast. You file this, you believe you're wrong, you want declaratory judgment. I want the court to tell us the answer. That's, okay, I can't come up with the decision, they can't come up with the decision. Court, you decide for us. That's what declaratory judgment is. So this court's going to have a number of things to do, and that's going to be look at the Constitution. Does it specifically give them this power? And if it doesn't, you have to tell them to stop.
Okay, again, our chief of the analyst, Khalif Rhodes, weighing in on that for us. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.